Share your light. Good. Yes. Good evening to all of you. We now discuss, we have finished the contract of indemnity with the various case laws because contract of indemnity comprise only of three sections, that is 124, 125 and 126. I have discussed the case law also on that. And please remember, as far as the case law is concerned, the case laws are mostly the English cases and the old cases. And as far as the searching the book is concerned, I couldn't find new cases as far as the law of indemnity is concerned. Perhaps if you are interested, you can go through the law of insurance. In the law of insurance, many cases are reported, but insurance, it's a contract of indemnity, is nothing but a contract of insurance, or where you try to compensate the other person the loss which he has sustained and put him back in the same position which he was prior to his losing a certain thing. Now we go to the contract of guarantee. They are almost indemnity and guarantee are almost like twin brothers. Each does not live without the other. They are inseparable twins as far as the specific contracts is concerned. First of all, the law of guarantee is found or prevalent in our day-to-day life. Here, law of guarantee has been defined as an agreement where a person, the surety, proposes to fulfill or perform the promise or obligation of another or undertakes the liability of a third person in case of his default, or where he agrees to pay a debt or perform the duty in the event of the failure of the other original person not performing his contract. Here, first and foremost is the contract of guarantee arises mostly in money matters. Here, what happens is normally no one trusts the dealer here. They insist on a surety being given or a guarantee being given that he will not commit default, and in case he commits default, the guarantor or the surety will be made responsible to pay the debt or perform the obligation which remains unfulfilled as far as the principal debtor is concerned. Here, the contract of guarantee, the essential ingredient is in contract of indemnity, we had only two parties, one called the indemnifier and another called the indemnified or the indemnity holder. But as far as the guarantee is concerned, we have three parties. One is called the creditor, another is called the debtor, and another is called the guarantor or the surety. So, the basic distinction between indemnity and guarantee is that in indemnity we have two parties, indemnified and indemnifier and indemnity holder. But as far as guarantee is concerned, but in indemnity you don't have a third party. But in guarantee we have three parties, that is the creditor, debtor, and the guarantor. Then what is the essence or the meaning of guarantee is to say that if any person is indebted to a creditor, then a third party who has nothing to do with the transaction undertakes to pay the debt or says that నేను హామీ ఇస్తున్నాను. Suppose that fellow doesn't pay the money, I will pay the debt. Or if he does not perform his duty, which is enjoined upon the contract between the parties, I will perform those obligations. That is, in other words, he intermeddles between the creditor and the debtor and ensures performance and says that in case of default of payment, in case of not discharging the indebtedness by the principal debtor, I will make the payment, I will undertake the loss, I will undertake the payment to the creditor. Or if the other side, that the debtor does not perform his obligations under the contract, I will perform it on his behalf. This is what is called a guarantee. Guarantee means హామీ ఇవ్వడం. That is to say that assure the creditor that you are safe, don't bother about it. I will see that the performance is done. I will see that the payment is made. In case the payment is not made by that person, that is the debtor, I will make the payment. So he undertakes the liability for and on behalf of the principal debtor and ensures the contract of performance is ensured. So that is the reason why guarantee plays a very important part in our day-to-day life. Please remember, for example, suppose you are a person in Hyderabad and the deal and the creditor and the person who supplies the goods to you is from Rajamandri. Then in that case, the person in Rajamandri does not know you, or you don't know him personally. It's only a contract for performance of a duty that A shall supply the goods and B shall pay on delivery, or B shall pay within a period of 90 days is the grace period given for performance of the duty. Then please remember the person at Rajamandri says, how can I trust you, sir? How can I believe you, sir? I have no acquaintance with you. You have to furnish guarantee of someone who is also known to me, so that in case you do not make the payment, in case you do not perform your duty by paying the money on delivery, that person will ensure the payment. So to ensure payment, to ensure prompt performance, or to ensure performance of a duty which has been omitted by a third party with whom the guarantor is not acquainted, then when he undertakes the liability, it is called a contract of guarantee. And the first fundamental principle, as far as the guarantee is concerned, the liability of a guarantor or a surety is coextensive with that of the debtor. That means the question is, the guarantor cannot say, sir, first you receive the payment from the debtor, and in case the debtor does not pay, then proceed against me. No. Once you have given a guarantee, once you have ensured payment, once you have ensured payment by the principal debtor, and you have stood in between, you are a mediator in the middle, and you have stood guarantee for the payment or performance of an obligation, you cannot escape your liability, but you have to perform it conjointly along with the principal debtor. So it is a triumvirate agreement between the creditor, debtor, and the guarantor. And the guarantor, a guarantor stands surety or guarantee for a person who is indebted to the creditor, number one, or for performance of a duty by the principal debtor. In case of default by the principal debtor, the guarantor should ensure payment, or he should pay from his pocket, or he has to perform what the debtor has not done. That is the crux of the law of guarantee. That's how guarantee has been defined. Where a third party who has nothing to do with the creditor or the debtor undertakes upon himself to stand in between and stand guarantee or stand surety and ensure payment of the money or performance of a contractual obligation, and also says in case the money is not paid or in case the duty is not performed by the debtor, I shall perform it for and on behalf of the principal debtor. That is what is called a guarantee. So I again repeat, the basic distinction between indemnity and guarantee is indemnity. There are two parties alone. One is the indemnifier, and the another is called the indemnity holder. There is no third party as far as indemnity is concerned. But as far as guarantee is concerned, there are three parties. One called the creditor, one called the debtor, and another called the guarantor. And a guarantee agreement is executed by the guarantor in favor of the creditor, saying that I am standing surety, I am standing as a guarantor for and on behalf of the debtor. I shall ensure performance of the obligations of the principal debtor, and I shall try to see that the principal debtor makes the payment or performs his contractual obligations under the contract. And if he fails to do so, or if he defaults to do so, I shall pay the money, or I shall compensate you, or I shall clear the debt, or I shall perform the duty for and on behalf of the principal debtor. Then it is called a contract of guarantee. Are you able to understand? Then we go further, sir. Here, uh, an agreement to a contract between two parties where one agrees to pay a debt or perform the duty in the event of the original party failing to do so. It is sometimes called a guarantee or a warranty. It can be absolute, meaning that the guarantor will assure the obligation for any reason, or it can be conditional, meaning that he will assume obligation under specific circumstances. Here, the contract of indemnity. What is the crux of the contract of indemnity, sir? Where a third party who has nothing to do with the principal debtor undertakes or ensures performance of the obligations, contractual obligations, or payment of the money as far as whichever is due under the contract. And he says that in case the original party, that is the debtor, fails to pay the payment or fails to perform his contractual obligations, I shall perform it on for and on behalf of the principal debtor. So this is basically a contract between the principal, between the creditor and the guarantor, and it is almost reduced to writing, whereby the guarantee is ensured, or where the creditor is satisfied that I need not bother about the money, I need not bother about the performance of the contractual obligation by the principal debtor. Here is a third party who has already come forward and ensured payment of the money or clearance of the indebtedness or performs the contractual duty for and on behalf of the principal debtor. This is normally called the contract of guarantee. Then going further, sir, the nature and scope, events and circumstances, representation and warranties. Warranties are considerations, subordination of certain indebtedness. That is, subordination of certain indebtedness means where the principal debtor is due money to the creditor towards a transaction, money transaction, or the principal debtor is liable to perform certain contractual obligations on behalf of the creditor, then to that extent he is indebted. Then in that case, the guarantor says, I will perform it, I will make the payment, I will stand as surety and ensure performs the contractual obligations, and it is said nature and scope, events and circumstances. So here the question of liability of the surety, when does it come, sir? If everything goes on well, if everything is in a proper shape, the debtor pays the creditor, and there is a good relationship between the debtor and the creditor, or the performs his contractual obligations step by step, phase by phase, point by point, there's absolutely no differences. The surety doesn't come into play. When does the surety come into play, or when does the guarantor come into play? The guarantor comes into play on in the event of the failure of the debtor to make the payment, number one, or failure of the debtor to perform his contractual obligations, then the role of the guarantor comes into play. Whether the guarantor likes it or not, once he executes a guarantee agreement in favor of the creditor, he is bound. He cannot say, sir, first proceed against the debtor and then come against me. I am not liable otherwise. But the basic principle of the law of guarantee is, please remember, the liability of a surety is coextensive that of the debtor. I will give you one example, sir. Suppose, let us say, most of us who are from middle class, we contribute to a chit fund and we are subscribers to a chit fund. And normally, a period of 48 months, 24 months, 12 months, 36 months, so on and so forth. It's fixed. Every month, I pay 1,000 rupees towards my chit amount. I continue to pay it for a period of 3 years. Then let us say an auction is held, and whoever is the lowest bidder, the chit is knocked down in his favor, and there's a contract which is brought about between the chit fund operator and the customer. And let us say that let us say total contributions which have come into the kitty is about, let us say, 3 lakhs, and I bid for 2 lakhs. Let us say I am the lowest bidder. Then what happens is the bid is knocked down in my favor by the chit fund company, and I am the successful bidder, and the chit fund company pays me 2 lakhs as per my bid. But please remember, they don't pay the money on a platter. What they do is, please try to get two sureties, two guarantors who are government servants, who are paid employees, so that they can ensure your payment later. Please remember that 2 lakhs also which is paid to you is not a gift. What you have to do is, when you pay the regular installments, along with the regular installments, you must also contribute 1,000 rupees or 2,000 rupees, whatever is fixed, till the chit amount which has been knocked down in your favor is satisfied. Until such time, your indebtedness remains. But suppose, let us say, the successful bidder, and they also take a guarantee agreement also from the surety or the guarantor. The surety or the guarantor ensures prompt payment not only of the future installments but also the amount that has been given to the customer towards the bidding amount. And let us say the bidder or the successful bidder pays the installments correctly, pays the EMIs correctly, pays the loan amount also correctly, absolutely there is no problem. The real problem arises if there is a default in payment of the installment or payment of the loan amount. The chit fund company immediately recalls the amount and then gives a notice to the debtor as well as to the guarantor to make good the payment. And please remember, most of you are happy that the chit fund companies are filing lot of suits in the courts. Please remember the very fact that the chit fund company is filing suits against the debtors and the guarantors itself shows that the end of the chit fund company is at its very end. Please remember, if one person who draws a chit, one person who is a successful bidder takes the money and then he does not make the payment, does not pay the EMI, does not pay the loan, the chit fund company will suffer a loss. So for that reason, they take the guarantee. And please remember the easy bakras who are available, easy scapegoats that are available are the guarantors. Guarantors are normally people of some stature, people who are occupying very good positions, people whose salary is almost definite. Whether they work or don't work, they get their salary. And the salary is attached. And from the salary, the chit amount or the loan or the EMIs are satisfied. Are you able to follow this? The question is the guarantor cannot take a plea, and without taking a guarantee agreement, the chit fund company will not release the money or will not give you the check to the successful bidder. The question is here in this type of contract, what happens is the guarantor says, "Sir, I shall ensure the payment of the regular EMIs every month and also the loan amount, every loan amount which is payable in installment. And in case the debtor does not make the payment, I will make the payment to you and I will compensate you as far as the failure on the part of the debtor is concerned." The guarantor binds himself to make the debt, pay the debt, or pay the debt to the chit fund company. Please remember now the situation has changed, sir. Now suits are not being filed by the chit fund companies. Straight away they are knocking at the doors of the doors of the registrar of cooperatives, whereby an assistant registrar is deputed by arbitration. The award is passed by the arbitrator, and the arbitrator is none else than the appointee of the chit fund company. And once an award has been passed, then what they do is the arbitrator has no power to execute the award. Only thing is you will have to go to a civil court and file an execution petition which you file in money suit and exhaust your remedies, whatever remedies are available to you under the modes of execution contemplated under Order 21 CPC. The advantage of this resorting to the arbitration procedure under the Arbitration and Conciliation Act of 1996 is that there is a quick disposal of the chit fund claim, and the court fee which is paid by the chit fund company is hardly 50 rupees or 100 rupees. But once you go to the court, you will have to pay court fee at ad valorem, that is according to the schedule. And please remember, I have even conducted arbitration matters appearing for the debtors, but there the arbitration proceedings are nothing but a farce. And the first date of hearing itself, you don't file your reply, don't file your counter, don't get ready with your evidence. Straight away the award is passed, and normally the award is dictated by the counsel who appears for the chit fund company. And please remember, once an award is passed, to get it set aside is a Herculean task because you will have to file a proceeding before the competent district court under Section 34 of the Arbitration and Conciliation Act, setting to set aside the award on the ground saying the principles of natural justice has been violated. But here, as far as execution petitions are concerned, first and foremost is the chit fund company first proceeds against the guarantor and then against the debtor alone. They proceed against all, no doubt about it. But once they are able to recover the money from the attachment of salary of the guarantors, the question is whether the debtor pays or does not pay. The chit fund company is not bothered. So the role of a guarantor, role of a surety comes only when there is a failure on the part of the debtor to clear his outstandings to the company concerned, and they are perform his contractual duty by paying the installments, not only the installments but also the loan amount in installments. If it does not pay, then the guarantor becomes liable. And the guarantor cannot take a plea and say, sir, first proceed against the debtor and then come against me. Please remember the basic principle. Again, I repeat and repeat and repeat. The liability of a surety is coextensive with that of the debtor. Then I will give you a model as to how a guarantee agreement is drafted. Please remember, every one of us has got our own way of drafting a guarantee agreement. And please remember, as far as banks are concerned, the nodal bank or the main bank is the State Bank of India. State Bank of India is none else than the successor of the Imperial Bank of India, which left this country, and ultimately the State Bank of India was formed under the State Bank of India General Regulations of 1956. Yes, 1956, 1955. I'm sorry. And then the subsidiary banks like State Bank, those days I'm talking about, subsidiary banks like State Bank of Hyderabad, State Bank of Travancore, State Bank of Maharashtra, so on and so forth. They adopted the same procedure. They adopted the format that was drafted by the Imperial Bank of India. And please remember, when you execute a guarantee agreement, the guarantor goes to the bank. He cannot read it. He is not given time even to read the contents of the guarantee agreement. He is only asked to sign on dotted lines. And then please remember, as you say, once he stands guarantee, once he stands surety, a beggar cannot be a chooser. That is the reason the guarantor is not given time even to study the document. Even we as advocates sometimes fail to understand the implications or the interpretations of the guarantee agreement. Here, the model form I could tell you is the way of drafting a guarantee agreement is, please remember who are the persons who are the parties to a guarantee agreement, sir. It is the creditor and it is the guarantor. Debtor does not come in the way. Here, this agreement of guarantee execute. I'm going very, very slow, sir. The format is this agreement of guarantee executed at Hyderabad on this the day of so and so, day of so and so, by and between number down here. It is. You say the State Bank of India having its head office at so and so place, and with this local office at so and so place, represented by its chief manager, hereinafter called the creditor, and or you say the name of the guarantor, I so and so, that is the guarantor's name, Mr. A, son of so and so, age so and so, occupation so and so, resident of so and so, so and so, hereinafter called the guarantor, which term shall include all his heirs, assigns, and legal representatives. Then, in favor of the State Bank of India, having its head office at Bank Street, Hyderabad, and having one of its branches at Abbots, Hyderabad, represented by its chief manager, hereinafter called the creditor. Next para. Whereas the guarantor is a solvent person, and the bank has extended loan facilities to X and Company, represented by so and so, and towards the discharge of the loan outstanding, the guarantor hereby undertakes to stand as surety and guarantor for and on behalf of the principal debtor, and also ensures the performance of the contractual obligations by the principal debtor by making the payment as far as the loan amount is concerned, and in case the principal debtor, whichever company it may be, does not make the payment or does not clear the indebtedness, the guarantor hereby assures the creditor that all the loan outstandings the due and payable by the principal debtor towards loan account number so and so and under so and so facility shall be paid and cleared by the guarantor for and on behalf of the principal debtor, which extend company. Then next para, you say, whereas the creditor has advanced a sum of rupees so and so towards so and so facility to extend company for working capital arrangements or cash money or bill discounting facility, and towards the and also took the primary documents like promissory note, etc., from the principal debtor, and to ensure prompt payment and clearance of the loan, the guarantor has executed this guarantee agreement assuring payment promptly and also stands surety for discharge of all the outstandings due and payable by the principal debtor, extend company, in case the principal debtor fails to make the payment not only for the present transaction but also for the future transactions from time to time. Next para. Whereas the guarantor has voluntarily stood surety or guarantor for the loan facilities granted by the creditor to the extend company, and also undertakes that in the event of the debtor not making the payment or not performing his contractual obligations or not clearing the present, past, and future outstandings, the guarantor shall make good that payment, assures making good that payment to the creditor towards the loan facility granted to extend company. Now, this guarantee agreement witnesses as follows: one, that the guarantor hereby declares that he is quite aware of the loan outstandings of the principal debtor, extend company with the creditor towards account number so and so, so and so, so and so, and towards so and so facilities. Number two, the guarantor hereby agrees and undertakes that the principal debtor is a solvent person and he will make the payment promptly and shall not commit any default as far as the payment of the loan amount is concerned. Three, that in case of default on the part of the principal debtor, extend company, to clear the outstandings from time to time in respect of the present, past, and future transactions, the surety or the guarantor undertakes to make good the loss and make the payment personally for and on behalf of the principal debtor, so on and so forth. Like that, you can add as many clauses as you like. And you also say there's also a clause included saying that this guarantee agreement shall remain in existence till the full discharge of the obligations by the principal debtor and the payments to be made by the guarantor from time to time in respect of the present, past, and future transactions. And this guarantee shall not be terminated without the consent of the creditor. And also, you say that this guarantee agreement cannot be revoked, cancelled, or modified or varied without the consent of the creditor. Then, next one is payment by credit guarantor. That is number one is that no duty to pursue. Uh, that is, first one is uh, that is no duty to pursue others. Here, as far as the guarantor is concerned, do or die, you shall make the payment in case the default is committed. You shall not pursue others and say, you take the payment, I will reimburse you later. No. Once you execute a guarantee agreement, you are only personally liable to clear the indebtedness as far as the debtor is concerned. Second one is waiver of notice. As far as once you stand as guarantee, once you stand as surety, the question is you can say that I want to waive the notice. No notice need to be given. I already know the contents of the loan transaction. I already know the contents of the guarantee agreement. I shall clear the outstandings. And third one is payment of expenses. So whatever expenses are incurred by the bank or the financial institution towards the loan, towards the legal expenses, towards the court costs, etc., the guarantor undertakes to make good that payment to the creditor. And the fourth one is payment of expenses. The next one is that effect of bankruptcy. Please remember what do you mean by bankruptcy or insolvency. In Hindi, they call it as Diwala. Here, there are two types of death which a person suffers. One is what is called physical death, and another is called legal death. Physical death is once you shed your mortal coils and leave this world, you die and you are not found there forever. But legal death means once you are declared as an insolvent, once you are declared as a bankrupt, or once you are or one I'm talking once you means the principal debtor. Then the question is once the guarantee agreement is there, in spite of the bankruptcy, in spite of the insolvency of the debtor, the guarantor is liable till such time the entire debt is repaid. Then next one is release of yes sir. Release. Huh, sir? Yes, sir. So please remember we are in Hyderabad. We are having heavy rains and there's disruption as far as the current is concerned. So please pardon us that today we'll stop here and continue tomorrow from wherever it is left. And
We'll continue the class, same class tomorrow, because there will be definitely a light failure of electricity. Please bear with us. Okay. We'll see you tomorrow again. Thank you.
the chat box and
Jai Srinivas. Srinivas garu, namaste. Srinivas sir.
Jai Srinivas.
Jai Srinivas garu, namaste. Madam. Srinivas garu, namaste. You can unmute, you can speak, sir. You can. Madam, shut down. Please.